talk a little bit more about all this, a lot more actually, with former federal prosecutor and CNN legal analyst Shan Wu. Shan, good to see you. So Alan Dershowitz, in his efforts to make the rounds and make it very clear from which point of view he's coming, he said something very interesting about his role, defining his role on this defense team. Listen.
I'm not involved in the day-to-day
But you haven't argued on the floor of the Senate dozens of times, or a dozen times.
No, I actually was on the floor of the Senate once on behalf of Senator Alan Cranston many years ago.
Okay,
but
in this case,
very few people have argued.
I want to make this clear because I'm not seeing this clearly, Alan. Who hired you?
I was asked by the president's defense team to become of counsel on the specific issue of the criteria, the constitutional criteria for impeachment. That's a very important issue. I will be making that argument as an advocate, not as an expert witness. I will be advocating against impeachment of this president based on the constitutional criteria.
So, Shan, why the need for this distinction?
He thinks the professor does protest a little too much, Fred. He seems to be concerned that he wants to keep his own reputation intact. I think he's afraid of being perceived as being too partisan or arguing the facts. He did have to walk back, I think, some of his initial statements because he was talking himself right out of a role. If he turns into a witness instead of an advocate, obviously they have to allow other witnesses to come in. But there's no question he's an advocate. He's owned that now. And there's also no question that there's not really any difference between his position and the president's White House team, Cipollone, and his private attorney, Sokolow's position. They're the same.
Yeah, who are saying that, the allegations of any wrongdoing don't seem to match the articles. That's been his argument. So, all right, so look at the calendar. We're now only 2 days away, from the start of this trial. So how much, do these House briefs versus the White House, briefs, how much of that will set the tone or give an indicator of just how these opening arguments may go on Wednesday?
I think they're an excellent preview of exactly how the arguments will go. The president's team wants to stay away from the facts, and they want to just stay at the level of constitutional arguments. That's one purpose of having Dershowitz and Starr there, to provide some constitutional law cover for the Republican senators to ignore the facts. The weakness of that argument, which the House really points out very well in their brief, is really Dershowitz and the president's team want to read out of the Constitution the impeachment provision. They're basically saying anytime you have an impeachment, it's going to affect the election of the people, the will of the people, and they would like to just have it removed entirely. That's the thrust of their argument, and that's really just, it does not fly. It's not a very strong argument.
I was going to say, what are your thoughts on that? Because the White House saying, you shouldn't be able to deprive, deprive the public of the power of voting for this president. That's essentially what that's saying, as opposed to really arguing against, the allegations, the accusations of a president, his alleged abuse of power by asking a foreign government to interfere with U.S. elections.
Exactly, that's what they're saying, and it doesn't make any sense. I mean, unless you want to take the view that there's a saying in constitutional law, there's no surplusage in the Constitution, meaning the framers didn't just throw in the impeachment provision because they felt like it. It has a purpose, and the purpose, of course, is after an election has occurred. So by definition, if a president is impeached and then removed, of course it interferes with the election for good reason. The framers were worried about a president who was going to abuse power, invite foreign influence, and cared so much about being reelected that he didn't care about his duty to the Constitution.
All right, I want to shift gears because you're a prosecutor of many things, but also that of sex crimes as part of your, credentials. So I want to get your thoughts on presidential candidate Andrew Yang's wife making a very courageous, powerful public reveal about being allegedly sexually assaulted by her OB/GYN while she was 7 months pregnant. So Dr. Robert Haddon, he faced charges and through a plea deal, escaped prison time or even registered sex offender status. After Evelyn Yang's interview this past week with Dana Bash, at least 15 more women have come forward, and this case now against Columbia University, where Haddon practiced, possibly they could be folded into that lawsuit. Can Haddon also now potentially face new assault charges since there are others who have now come forward?
Unfortunately, the answer is probably not. It depends on the wording of his plea agreement. But a plea bargain is like a contract between the prosecutors and defense counsel, and if it was worded properly, and he had some very skilled, high-priced lawyers, I'm pretty sure they worded it properly, to be very broad, which would be any incident arising out of his practice at Columbia University Hospital was going to be covered, and the government would have said, we won't prosecute for anything else if you plead guilty to this. So they basically sold those victims down the river and deprived them of the chance, both future victims that they didn't know about, as well as those who had already survived the assault that he admitted to.
Wow. But then again, there's that ongoing case now against Columbia University, which is, you know, the medical offices where he practiced. All right, Shan Wu,
Exactly.
thank you so much.
Good to see you, Fred.
You as well.